All right, so I think we can go ahead and get started. So first, just a few notes before we begin. If you haven't figured it out already, the webinar host cannot see you or hear you, so don't need to worry about muting yourself. The format of this webinar is going to be about a 40-minute presentation, and then afterwards we're going to do a 20-minute question and answer session. If you need to ask a question, please use the chat box function. And after the webinar, if you feel like you need some one-on-one advice on how to do some estate planning or to get some estate planning documents done, please give us a call at our intake number that we've provided. With that, I'd like to introduce Gabrielle Richards and Christie Martin. They are two wonderful attorneys in Clark County, and we are so thankful that they were willing to put on this webinar for us for free. So go ahead and take it away, Gabby.
Thanks very much, Audra. My name is Gabrielle Richards, and
Gracias, mi nombre es Gaby.
With Christie Martin. And you might hear a little bit of delay in my speaking.
Vamos a escuchar un poco de
being translated into Spanish for our Spanish speakers on.
Y va a haber un poco de tardancia en la interpretación porque está la intérprete de español aquí.
So Christie and I practice in the area of elder law and estate planning, probate, guardianship, and conservatorship.
So Christie y yo hablamos en el área de planificación.
And today we're going to talk about many different types of estate planning mechanisms. We generally divide them into two different categories.
Y hoy vamos a hablar de diferentes tipos de mecanismos. Generalmente los dividimos en varias categorías.
I'm going to discuss what we refer to as your dead papers, which are applicable whenever someone has already passed away. And Christie is going to talk to you about what we call the alive papers.
So, yo voy a hablar un poco de los papeles que se tendrían que llenar después de que usted fallece, y Christie va a hablar un poco de los papeles que se tendrían que llenar durante su vida.
And I just wanted to say, you know, we're obviously working in unusual times, and we're at our homes. And so if you happen to see dogs running by behind Christie, or Christie getting up out of her seat to tend to the dogs, please forgive us in advance.
Y generalmente tratamos de que todo esté silencioso, pero si oyen como perros o algo, por favor, le pedimos disculpas de antemano.
And just as a quick note, we'd like to point out that estate planning is unique to everyone. So while we try to sort of talk about things that would be applicable to everyone, your individual situation will vary.
Igual quiero también darles a saber que las situaciones de las que vamos a hablar no necesariamente tienen que aplicar a todos, pero vamos a hablar de diferentes temas.
And so when we get to the end of our presentation, we're going to ask for your questions. We want to make this as interactive as we can, but we won't be giving legal advice to anyone. We encourage you to call back the Volunteer Lawyers Program after if you wish to make an appointment with someone to come in and talk about estate planning. But we will answer some generally applicable questions as those come in.
Y también le queremos dar a saber que ahorita vamos a tratar de contestar todas las preguntas, pero si ocupa consejo de un abogado, entonces en ese caso tendría que hacer una cita con alguna de nosotros y podemos hablar personalmente.
And with that, I will turn it over to Christie, my law partner, who's going to talk about your so-called alive papers. Take it away, Christie.
Y con esto vamos a hablar ahora con Christie, que vamos a hablar de los documentos que son aplicables durante su vida.
I think Christie.
This is Christie, and I thank Gabby for giving me that introduction and an introduction about what we're doing here today. I'm here to talk about what we call our alive papers. They are papers that may be even more important than your dead papers regarding wills and trusts and things like that. So I'll be talking about three particular things today and then some optional documents that you may want to have in your toolbox. The things I'll be speaking about today are a power of attorney for healthcare, a power of attorney for finances, and an advance directive. Here in Washington, we have 3 documents that we think are essential in your estate planning toolkit. I'm going to talk about the first one, which is a power of attorney for healthcare. So say, for instance, you get into an accident or something happens where you're incapacitated, you're unable to give your own direction to healthcare workers or doctors or something like that. What you need to have on file and with your toolkit for your estate plan is a healthcare power of attorney. We recommend this because you need someone to speak for you on your behalf if you can't do that. You're in a car accident and you can't speak to someone. You need someone to come in and make decisions for you to the doctor that you're not able to do. One of the things that in Washington State, we have the statutory provisions that allow immediate family members to make decisions. There's a whole network, like if your parents are still alive, your brothers and sisters and things like that, they can make decisions for you according to the statute in Washington. However, imagine that you don't have a relationship with them, or they've passed away, or you don't like your brothers and sisters. You need to have people there that are capable of making decisions for you when you can't. So we recommend that you have 2 people. The first person would be your primary person, and then the second one would be a backup. And then just allows you to have that peace of mind that says, hey, if something happens to me, I'm very confident that person A can make the decision for me. And if person A isn't available, I'm confident that person B can make that decision for me. So that's the first thing, is a healthcare power of attorney. And we have, if we have time later, we can tell you stories about people that don't have these documents in place and what problems they had to go through in order to remedy their situations. The second document is what we call a durable power of attorney for finances. And again, this is a document that we recommend you have in your toolbox in case you are.
I'm just doing webinars right now because I'm helping Audra and I'm in a call. What's going on?
I'm sorry. I'm sorry, we just had a short interruption. So a durable power of attorney for finances is what we need in case, again, you're incapacitated and you can't make a decision, or you're unable to instruct someone to make a decision for you regarding anything that you have as far as financials. In other words, if you're in the hospital, you can't communicate, but you still need to pay your bills, the person named in this document can do that for you. There's all kinds of things that we can put into a durable power of attorney for finances. But most importantly, can they act for you? Can they step into your shoes if you're unable to do it? And there's a difference between, and just want to caveat here, there's a difference between a general power of attorney and a durable power of attorney. A general power of attorney ends at the time you become incapacitated. A durable power of attorney will go through the incapacity to the other side unless you revoke it beforehand. So when I say step into your financial shoes, that's a pretty big deal. So whatever you can do right now, in other words, you can sell property if you have it, you can go to the bank and open accounts, you can get into your retirement account, you can do all kinds of things. When you give that power to somebody else, they can do the very same things. So they would be able to step into your shoes and do the very same things that you can. Now, that being said, you can limit the powers of the person that you give the power to. You can limit them. You can say, well, they can only get into my bank account if I can't to pay my rent, or if they can only do this or that. Or you can give them all of the power that you have for the period of time that you're incapacitated. And this is very helpful for a lot of different reasons. And I want to make sure that you know that the person giving the power is the one that we would represent or that you would go to for assistance. We have a lot of people that call and say, I need to get a power of attorney for my mom. Well, that's not exactly the right way to say it. Mom needs to give the power to you. So she's the one needing to get the power of attorney, not you getting the power of attorney for your mom. So I hope that that's clear. Mom would be the one that needs to get the power of attorney because she is the one giving the power to the person, either you, another sibling, somebody else. So that's who needs to give the power. And we can talk more about those if you have questions, please ask them. And finally, the last alive document, and then I have a couple more, is what we call an advance directive. And a lot of people refer to this as the living will. So don't get confused later on when we talk about wills. So this is an advance directive. And in Washington, what this does is it's different from a healthcare power of attorney. A healthcare power of attorney allows someone else to make decisions for you on your behalf during your lifetime, during an incapacity. An advance directive is just exactly what it says. It's directing someone to do something when you are in advanced state of medical distress. In other words, end of life decisions. While you're alive, you can make the choices that you want for those end of life decisions and leave that in a paper that allows everyone to know what that is. In other words, if you are in end stages, and I'm not a medical doctor, but I'm just going to say there's no hope for recovery and things like that. Do you want to have life-saving treatments? Do you want to have a ventilator? Do you want to have a feeding tube? Those type of things. And if you're able to do that now, that will take a big load off of the people that you leave in your care. In other words, they won't have to make those decisions for you because you've already made them yourself ahead of time. So that takes a big burden off family members when you have an advance directive or a living will. And again, those documents are all malleable. When I say that, I mean they can have anything that you want in them. We have people that put their own things in there. Oh, I only want to have pain medicine. I don't want to be in pain. I don't care about anything else. Anything that you want, you can put in there. And that's a directive to the physician that says, these are the things that I want in my own words, in my own time, while I have a sound mind. So that's a pretty important document. A couple other documents that we are seeing a lot of people doing are what we call a mental health power of attorney. Now, this is a very important document because a lot of people may have some mental health issues and are on medications and things like that that will allow their disabilities to be noted. In other words, somebody may be schizophrenic and they're on a certain medication all the time. And sometimes when that medication stopped or accidentally they go off, sometimes they can be in crisis. So what a mental health power of attorney does is it's a very nice document because it works with the person that's affected by whatever crisis they have. It works with their mental health team, and it creates a plan that says exactly that. If I am in crisis, this is what is wrong with me. These are the medications that work for me. Instead of somebody being in crisis, going to the emergency department and everybody having to figure out what's going on, this document says, this is exactly what's going on. I'm off my meds. These are the meds that I take. Please give me these meds. Don't give me these meds because they don't work. So that's a very good document that we've come up with in the state of Washington. And we have had a lot of success with that and clients going forward, getting a mental health power of attorney. Again, it's the same thing. Your agent or the person that you as the mental health person gives to the agent that you decide, they know already, they have that document. They know that if you go into the hospital and you are in crisis, they are going to run there with this document and say, here's what you need to do to treat this person. So it's very effective. And finally, the document that I'll talk about is what we call a dementia directive. Now, a lot of us know that our parents get older and they sometimes will have some sort of Alzheimer's or dementia directive. And some of the things that we talk about in planning is, well, does it run in your family? If it does, would you like to have your wishes known in case you do get it. So basically it's just a small document that just says, you know, if I get this and if I'm in this stage of dementia, please just comfort care and things like that. So it's a very nice document to have if you feel like it runs in your family, if you know, maybe you have early onset. This is how I would like to live my life going forward. And you tell people now while you're in sound mind and while you're fit, these are my real wishes. That way it can't be disputed when you're no longer able to tell what your wishes are. And with that, I will hand it over to Gabby and see what she can tell us about wills and trusts and things like that. Gabby?
Thanks, Christie. And David, I do see your question, and I'll talk about that in a couple of minutes. I wanted to add to what Christie is talking about and saying that, a lot of people come to us and ask, do I really need to do estate planning? Because I don't have an estate. I don't have property. I don't have a lot of money. So I don't really need an estate plan. And our response to that is, it's true that you might not necessarily need something like a will or a trust, but I believe that everyone should have at least 2 or 3 actually of the documents that Christie was referring to. You might not need a mental health power of attorney or a dementia directive, but I believe everyone needs the power of attorney for finances, as well as the 2 healthcare decision-making documents that Christie mentioned. And those are often overlooked, and that's one of the reasons why we divide our presentation into 2 separate sections, talking about those, quote, alive papers and then the dead papers, because they're helpful to everyone, no matter your age. We don't know what's going to happen to us today or tomorrow, or even 5 or 10 years from now. So it's helpful to have those documents in place. So David asked a question about the best practices for withdrawing a power of attorney and minimizing the chances of a former grantee trying to exercise a withdrawn POA. So it's a very good question, and that's something that we deal with in our practice, unfortunately, quite a bit, is when someone has sort of gone wild with a power of attorney and is doing all kinds of things that might not be in the best interests of the person granting the power. So when you revoke a power of attorney, it certainly should be done in a writing. So there are forms. It even doesn't have to be a formalized form. It can just be something written down that says, I hereby revoke the power of attorney executed on such and such a date. And then our recommendation would be to present that document of revocation to banks and others who deal with those powers. I will say that even the best drafted power of attorney done by an attorney sometimes is not accepted by a lot of banks. We see this mostly with larger banks, national banks, who want you to execute one of their own power of attorney forms. And although it's frustrating, and a power of attorney drafted by an attorney is a legal document that they should be respecting and honoring, instead of fighting about it, we just recommend that when you do a power of attorney, that you take the power of attorney to your bank or other financial institutions or people you deal with, and make sure that they will accept it. And if they don't, go ahead and execute whatever form that financial institution wants you to sign that is specific to that institution. So whenever you're revoking, make sure that you also revoke those powers of attorney that might have been signed with individual financial institutions. Regarding, just sort of preventing someone from further exercising a power that has been withdrawn, a strongly worded letter to the person who's been given the power is always a good idea, saying it's been revoked. But certainly, like I mentioned, making sure that those persons who have been, banks and so forth, have the revocation on file. There's another question, and I want to address all of the questions that we're getting in the power of attorney section now, because I don't want to miss anybody as we go through. There's another question from Gabriella that says, what's your recommendation for children with intellectual disabilities when they're about to turn 18 years old? So I don't know if this question is, you know, for parents of someone with an intellectual disability. If it is, and the person who's about to turn 18 does not have capacity, then we're looking into the world of guardianship. And that's something that, you know, you would need to consult an attorney for to see if that's the appropriate mechanism. And Gabriella, if I'm not answering your question, please feel free to post again, but it kind of sounds like that's what you're wanting to know. Someone else, Marianne, has asked about a POLST form. A POLST form is very similar to an advanced directive that Christie was talking about. The differences between a POLST and an advanced directive is oftentimes you'll have a hospital that wants you to sign a POLST, and it'll be on record at that hospital. But an advanced directive is a more portable document, and it's something that you know, wouldn't necessarily be on record with a specific hospital, and so it would be applicable to everything. The question regarding what if it conflicts with an advanced directive, or even what happens in the instance where you have someone who's executed more than one POLST. Maybe you have a POLST that was executed at hospital A and then another one that was executed with hospital B. This is actually something that comes up frequently. And generally speaking, the most recent one is the one that is applicable. So if there's any conflict, you might see a situation where a hospital or a doctor doesn't necessarily want to honor any POLST or advanced directive. But generally speaking, the most recent one would be the most applicable one, and that's the one the doctor or hospital would follow.
I step in for a minute and just say, please, you really want to avoid that situation where you have a conflicting thing like that, because that can end up in court, and it's not going to be an easy thing to resolve. I had a client once that was unable to speak, but there were two conflicting documents, and one was from a not so nice part of the family, and the other was from the other part of the family, and we ended up having the court decide which one would come into play. So please try and make your wishes known and keep those in line with all documents being current.
Absolutely correct, what Christie just said. What I'll say is, so I'm going to talk a little bit about what we call the dead papers. So all of the things that Christie just mentioned, in particular the durable power of attorney for finances, terminate when you pass away. So if I pass away and I've given a power of attorney to somebody, as soon as I pass away, that power of attorney ceases to be a functioning legal document. So somebody can't take care of my estate, my assets, my home, or whatever after I pass away just because I've given them this power of attorney. It terminates. So the documents that, there are many different estate planning tools that we can use whenever somebody passes away to give somebody else the authority to deal with someone's estate. The most basic one is a will. And you know, not everybody needs a will necessarily. Like I mentioned, there are lots of other things that we can do in the estate planning process that might eliminate the need for a will. And the reason we might want to do that is simply to avoid probate, because when you have a last will and testament, and there's something that needs to be resolved in an estate, generally speaking, you have to go through the probate process, which simply means that a personal representative or personal administrator is appointed to gather all of the assets, to sell homes, and then make distributions to the legal heirs of the estate. And it's not a big deal. A probate is not a big deal, but it's certainly an expense that can be avoided. And so if we can avoid the expense of of a probate, then we like to do that. There are instances when you don't need to probate. For example, if the estate is under a certain value and there isn't any real property in the estate, in Washington, we can do something called a small estate affidavit, but that's not an estate planning tool, so it's somewhat outside the scope of our presentation. There are other things that you can do to prepare your estate. For example, you can put beneficiaries on your financial accounts. That's something that does not go through the probate process. So if your only holdings are financial accounts, simply putting the beneficiaries on those will enable your financial accounts to pass to the person who you want designated. And with anything like this, whether we're talking about your alive papers or your dead papers, or putting somebody on an account, we always recommend that you revisit those designations of who you named to act on your behalf or who you want to receive your property periodically, because 10 years from now, the person who you've designated might no longer be alive, or perhaps you've fallen out of touch with them and you don't want them to be involved in your life anymore. So always revisit these things. But certainly designating people on your accounts is one way to not need an estate plan. You can also do things if you own real property, like a transfer on death deed. So if I own a home and I want it to go to my sister upon my passing, then I can record a transfer on death deed so that whenever I pass away, that home will automatically pass to my sister and she doesn't need to go through the probate process. So a will can be it's a very simple tool, and it sort of gathers up all of those assets that we haven't taken care of in some other way. So if we haven't designated anybody on an account, or perhaps we designated somebody on an account, but that person's dead, then it falls into your estate. And the will capture all of those things, and it simply designates persons to act on your behalf, and it designates persons to receive your property upon your passing. Again, this is a document that's a relatively simple thing to do. There are requirements under Washington law for how such a document is to be executed or witnessed. And so it's always a good idea to make sure that you're doing it properly. But that's a very simple estate planning tool that we recommend that everyone have, even if they don't think that they have an estate that requires a will and testament. The other estate planning tool that I'll talk about just briefly is a trust. And we get a lot of questions about trusts. People will come to us and say, I need a trust for my estate planning purposes. And I'll say this about a trust. A trust is, generally speaking, a lot more expensive for an attorney to draft than is a will. The advantages of having a trust is that a trust doesn't need to go through probate. So if you have all of your property in the name of the trust, then it simply passes to those persons whenever you pass away, and the trust is administered by a trustee. The difficulty with a trust is that a lot of times people will spend a lot of money drafting up a trust, but if you don't title your assets in the name of the trust, all it is a piece of paper. So then you have all of these assets that haven't been titled in the name of the trust, and I'll explain what that means in a minute, that aren't in the trust, and then you have to go through the process of a probate anyway. So for example, if I create a trust for you, then what I'll advise you to do, or if you want me to do it for you, is if you own a house, then I'm going to then transfer that house into the name of the trust. That puts the trust or the house in the trust. I would also do the same thing with bank accounts and so forth. But if you don't take that step, or somewhere down the road you forget to do it, you buy another house, you open another financial account, and you don't put those assets in the trust, all it is an empty piece of paper that doesn't really do any good. We don't really recommend trusts very often, except in the situation where someone has a lot of assets. So if you only have a couple of financial accounts, which you can name beneficiaries for. Or if you only own 1 or 2 pieces of property and you can do a transfer on death deed for those, there's really no reason for you to have a trust. So there's not a whole lot of reason for you to spend the extra, thousands of dollars to do a trust and everything associated with creating a trust to take care of those properties. We get a lot of questions about trusts from people from California, because probate in California is very expensive, much more so than in Washington and Oregon. So it's something that people in California think about and think, oh, I need a trust, and you really don't. So let me go through and I'm going to take a look at some of these questions here and see if there's something that I need to respond to. Please be patient. Marianne asked question, is a pension a financial account to which you can add a beneficiary? And you're correct that it does, it depends on what the terms of the pension plan are for. If the pension stops paying out whenever the person passes away, then you can't put a beneficiary on it. But if it's a 401k or some other retirement account, yes, that would act in the same way as a financial account. You would just designate beneficiaries for that. And I think Christie responded to that question as well. So Christie, do you have anything to add to what I just mentioned regarding so-called dead papers?
No, I think that's pretty good. Everything is covered as far as I know. Again, a lot of people will come to us and think they have, the thing that they think they need. They'll tell us, well, I need a trust, or I absolutely have to have a trust. And once we drill down and talk to them a little bit, it doesn't end up being that they need a trust at all. So, and I just don't want anybody to be afraid of the term estate planning, or you have to have an estate to have a plan. That's not the case at all. They're very personal papers, and everybody, like Gabby said at the beginning, everybody is different. Everybody's situation is different. So I want you to think of it as more of a personal papers. What do I want to do with myself if I can't make a decision? What do I want to do with my things after I'm gone? Basically, that's pretty basic.
So Marianne has asked a question, where can we find models for these documents that can be modified and adapted to individual needs? So there are resources online that you can turn to, and this is a difficult situation because I really don't like people going to the forums, and I don't want to sound as though I'm encouraging people to incur the cost of an attorney. I'm not. There are resources for people who can't necessarily afford the rates of a particular attorney. You can go to through volunteer lawyers, you can go to clinics, and there are some other resources out there for low-income individuals. I don't recommend that people go places like LegalZoom, you might have heard of, and so forth, because everybody's situation is really individualized. And I've seen it in my practice so many times where someone has gone to LegalZoom or to some other form-based thing, and the documents that they've done are not valid legal documents because perhaps they weren't executed properly or for some other reason. So I really encourage people to not use form-based products for their estate planning. These are documents that, at minimum should be, done in a legal setting so that you make sure that your estate is taken care of. I'll give you an example of one case that I had where the family was trying to save a little bit of money. And when they did the estate planning, they went to LegalZoom. And they did a power of attorney document thinking that the power of attorney would do the same thing as a will, and it didn't. And so when the person passed away, they didn't have a will. They only had this power of attorney that they got from LegalZoom. And unfortunately, when you don't have a will, what happens is your estate passes according to what's called the intestacy statutes of the particular state. And in this situation, the person who died didn't want her assets to go to persons under the intestacy statute, but she didn't have a will, and so that was really the only recourse. So I think it's important to consult with an attorney, whatever your means are, and seek out resources that would be able to assist you.
Gabby, I have a question from someone that says, do you need an attorney to make changes to your existing estate, such as updating a power of attorney, executors, etc.? And I'll take that question. So what you do when you update a will, so a lot of people, and I've had clients come to me that say, well, I made the changes already. I just scratched it out and put in their name. And I'm going to tell you right now, that's not going to fly. So what you need to do when you update a will, and we recommend that you look at your will every 3 to 5 years to make sure that things are there. In other words, you may have given Aunt Sally that big Picasso painting and then you really don't like her anymore, so you don't want to give it to her, so you scratch her out. That's not going to work. Aunt Sally's still going to get the painting when you die. So what you have to do is do what they call a codicil. So you make the adjustment to your will in a totally separate document that's updated and executed exactly the way you did your original will. So if you want to change your executor in your will, you do what you call a codicil in Washington State. And that's a pretty easy document. If you go to an attorney, it shouldn't cost you too much money. We don't ever, of course, recommend doing it by yourself. But I mean, obviously it is possible, but do you want to take that chance and have it be done incorrectly, and then you're not getting what you need once you pass away? As far as power of attorney is, and when you say updating, if you want to change the people in the power of attorney, in other words, you are the one giving the power, yes, you can update that document by doing a new document. You can't, again, scratch out people's names and put in a new name. We suggest that you do a new document and execute it in the same way that's done. Is there anything else you want to add to that, Gabby?
No, I think you covered it. We've also had instances where someone has wanted to amend their will or their power of attorney and simply crossed out things by hand. And like Christie said, anything that you change in a will has to be done so in the same way that a will would originally need to be executed. So that wouldn't be a valid change. Someone asked about a holographic will, and so a holographic will is, essentially if I took a piece of paper and wrote down, I leave my estate to such and such, and you sign your name. If I do that in the state of Washington, then that would not be considered to be a valid will. Washington does not recognize holographic wills that have been drafted and signed in Washington. There's a chance, though, that if you drafted a holographic will in some other state, and if that other state's laws allow a holographic will, that it would be admissible to probate. But again, I would encourage you that if this is your situation, that you redo your will so that it complies with the signing requirements under Washington law.
So I'll take the next question from someone who says, is there time when someone could discuss the care of minor children and how that's handled in dead papers? And that's an excellent question. And I'm sorry we didn't bring it up earlier, but that is a big deal. Let me tell you why. We have lots of folks that come to us that have minor children. Some have minor children with special needs and things like that. Now we're talking about both parents out of the picture for whatever reason, that they're incapacitated, they passed away or something. So now what happens to my minor children? Or even in the interim period when you are incapacitated, both of you, who takes care of them? Who can do school, legal things for them, take them to the doctor? Excellent questions. You can do limited powers of attorney for your children when you're incapacitated. Same thing. You're going to allow grandma or uncle or somebody to say, okay, he's allowed to take them to school, do everything they need to do with school, take care of their medical, do all of that stuff in a power of attorney. As far as after you've passed away, there's also who you want to name as a guardian. You can also do financial things for the kids by way of what we call a UTMA account, Universal Transfer of Minors account. And every bank knows what that is. You want to lock up money for your kid until they're 21, or just allow them to have money available to them for educational expenses and things like that. Again, we address this in a will or a trust. Also, who's the named guardian? And that's very important, because if you don't name somebody in your will to take care of your minor children, it may be up to the state to name somebody, and they're going to go through their process of guardianship, which includes a stranger coming in, doing an assessment and deciding at that point, well, okay, state and court, we think this person should be the best person to take care of these children. And it might not be the person that you've had in mind. It might be a suitable person, but it might not be the person that you've had in mind. So that's an excellent question and an excellent thing to plan for. And again, the reason we ask you to look at your plan going forward about every 5 years, because sooner or later, you're not going to need that anymore, and you won't have to worry about putting that in, and you can change that in your plan. But that's a very good question. Thank you for asking.
Yeah, I agree. That is a very good question. And there are things that we can set up in estate planning docs. And when I refer to we, I'm not talking about Christie and I'm talking about estate planning lawyers in general, but there are things that we can set up inside a will or a trust that creates sort of sub-trusts for the care of minor children, at least their financial needs, as well as any of their medical needs. There was a question from Ruby about what is the cost of a will, and I'm going to give you a typical lawyer response to that and say that it varies. You know, all lawyers varied on their prices. We typically do a fixed fee for our estate planning documents, so they really range. And so I'm going to just leave it at that and leave you with our general lawyer answer. But I suggest that you talk to multiple attorneys and make sure that the attorney that you're working with is a good fit, and also that the price that they quote you is something that meets your needs.
I have another question. Well, hang on a second. I have another question from someone who says, if you have your plan and everything drawn up in Washington and you move to another state, do you need to redo everything when you move to the other state? Gabby, do you want to take that?
Sure. So the short answer to that question is no. A will drafted in Oregon in 1978, so long as it is a validly executed will under the laws of that particular state, is still a valid document in Washington. So just because you've moved to a different state doesn't necessarily mean that the document that was drafted in Illinois won't be something that can be probated and legally acceptable in the state of Washington. And the same would be true of a trust or a power of attorney and so forth. I will say that some states have different, and this is generally with regard to advanced directive and medical forms. For example, in Oregon, I'm licensed in that state as well. We don't have really a need for a power of attorney for medical decision making because we have a statutory form for advanced directives. And Marianne, I think this goes to your question as well about a resource to point people to. Because it is a statutory form in Oregon, the advanced directive is something that an attorney doesn't need to draft. It's something that an attorney might want to advise on, but it's certainly, it's a relatively easy form to fill out and to have executed. So I would say that the medical decision-making forms might be something that you'd want to change in the estate or the state that you are in currently if you've drafted it someplace else. Let me see here. So there's another question from Rebecca about life insurance company that provides a free will kit. Is there something additional that we need to do to make sure it meets Washington law? Here again, this is sort of the same answer that I'll give you with regard to forms and kits. You know, these are just general things, and I would just be really reluctant to use a kit that's been prepared by a life insurance company because there are certain things that need to be met with regard to Washington law for executing a will. And so I would be really reluctant to complete a form or a kit that hasn't been prepared by an attorney in Washington who's familiar with estate planning requirements in Washington.
One of my favorite things that we do on these type of presentations is to give you my fake email address and tell you that if you go to the web and you get that form, and then you need to go to the other website called www.ihopethellthisworks.com, because that's what you're going to leave to the people that you leave behind. Are you really sure this document is going to help them, or is this document going to hurt them? And the only reason that we're saying this is we've had to fix so many things that people go and try to do themselves. And we're just saying this from experience. If you're worried about the money and you meet the qualifications and requirements, then the volunteer lawyers can help you. There are resources out there that can help you complete the things that you need at the price that you can afford or not afford. You know, some places there are resources that will assist you and review the documents that you've done. But please, please, please don't try to do it yourself because you're only leaving what you don't know that you're leaving. I guess that's a good way to put it.
So Tanya asks a good question. Where are the wills and documents stored? How long do you retain drafted documents for clients? So this is a sort of a changing trend, and it's something that we run into in our practice all the time. We do not retain original documents for our clients. There are many attorneys that do. This is more of an old school thing that attorneys, you know, maybe 10 years ago used to retain the original and give the copy to the client. We don't do that because number one, we don't want to be responsible for it. And, you know, we don't know, you know, if you, for example, if we have a client who passes away, you know, who knows that that will is in existence and so forth, and who drafted it and who to go to find that original will. So we always give the original wills to our clients in binders and so forth, and encourage them to keep it in a safe place and make sure that they have notified the people who will be acting as their executors and agents under a power of attorney of the existence of those documents and where to find them. So we do not keep those on file. Again, attorneys differ on this. There are some attorneys who do keep original wills. Wills also can be filed with the court so that, and I just had this happen recently where I had a client whose parent had passed away. They knew that they had drafted a will. They didn't know the attorney who drafted it, couldn't find it in the house. And we just did a very simple search with the court database. And we were very fortunate that the parent or the attorney who drafted it had recorded or filed the original will with the court. And so we didn't need to go on a hunt to find the will or to find the attorney who had drafted it, but rather could just go to the court and retrieve it from the court. Now, I will say that simply filing the will whenever you draft it with the court doesn't mean that you've submitted it for probate. Those are two very distinct things. You would still need to go through the process, if appropriate, to have a personal representative appointed in order to probate that estate. But it's just simply a way for anybody who needs to find the will to go to the court and to find it. So that's another option that we always give to our clients is we can file this with the court if you want, or you can retain the original. I'm a member of several attorney listservs, both in Oregon and Washington. And I frequently get emails from other practitioners who are looking for the will of, you know, so-and-so. And it might be that, they don't think there's a will, but they want to just do their due diligence to make sure that there isn't someone out there who has it. But it might also be that they, maybe they know there's a will, but they're just trying to find it. So I think that I hope it answers Tanya's question about that. It was a good question.
I have a question following up on guardianships for minor children regarding the guardianship. It says, what can a person do if the remaining parent is not incapacitated but is not a safe person? And then they follow up to clarify the remaining person has no legal restrictions with regard to the children. So I'm gonna play that I have enough experience with family law to be dangerous, but if the remaining, if mom and dad have a child, mom passes away in a car accident, dad is left, but they're divorced, dad still has parental rights, then he is probably going to end up being the guardian unless there's something that's prohibiting him from doing that. And that's, again, that's a family law situation that would have to be dealt with in a family law court. So I think that's right, Gabby. You can jump in on that if you have anything to add.
Yeah, that's right. I think that's more of a family law question, unfortunately. And it really has to do with the specific situation of whether that other parent, if there's something preventing that other parent from being the legal guardian of the minor child, it just is really a family law question. Yeah. So I'm looking through, I'm hoping that we've covered the questions that have been asked. Are there any other questions out there from anybody? We'd be more than happy to take your question. Christie, do you see any questions in there that we might have missed?
No, and I've had some questions directly and I don't see any. I think there's a family law attorney that piped up on that question.
Oh, good. Yes, I agree. So I always joke that, people call us and there's a lot of overlap between areas of law. We do a lot of guardianship, which sometimes can overlap with family law. Estate planning can overlap as well. And it's like if you go to a doctor and you have you go to an internist and you have a problem with your foot, the internist is going to say, go to the foot doctor. And we unfortunately have to do the same thing in law, that if it's something that is outside of our practice area, then we throw it back to those who are more appropriately suited to ask or answer those questions. And the question about parentage and guardianship and so forth is definitely a better question for a family law attorney. Marianne asked, do you offer a similar presentation that focuses on Oregon law? Absolutely, we've done many of these types of clinics and presentations in Oregon that talk about the specifics of Oregon law. One thing I'll throw out there is that part of our practice is we have something called the Cascadia Mobile Legal Clinic, and the Mobile Legal Clinic is it's actually it's an RV, and we take it to rural areas primarily in both Washington and Oregon, and meet with folks who might have difficulty getting to access an attorney, and we give both presentations and also individualized legal advice regarding our areas of practice. And so we've done that in both states since 2015. Okay, any other questions out there that we might be able to answer or throw back at another area of practice?
I think there is one question. It's, do you practice special needs endowment trusts?
Yes, that would be, well, yes, we do special needs trusts. We do in Oregon, they're called income cap trusts as well. That's a little bit different than a special needs trust. We certainly do those things if it's appropriate to be done in the specific circumstance. Any other questions? You're welcome, Marianne. Thank you for participating and asking good questions.
I will just follow up and say, if there are any of you out there and you do come up with some questions afterwards, you can always send us an email at info@ccvlp.org, and I'd be happy to pass your questions on to Gabby or Christie. Well, with that said, thank you, Gabby and Christie, for both putting on this presentation. It was super helpful. I also learned a lot.
No problem. We've enjoyed it. And again, you know, we don't want the estate planning process to be scary. I think that there are certain documents that everyone should have in place. And fortunately, there are resources out there for people of all incomes. And so I really encourage you to consider doing some of these documents and talking with someone who can assist you.
All right, well, we will go ahead and conclude the webinar. Thank you all for attending today.
Thank you, everybody.